My lord, I am for the my lord. Appellant, plaintiff appellant. Plaintiff appellant, my lord.
Just one.
File a suit for my
Just
lord.
1 minute.
To appear for respondent defendant number 1, my lord.
You are selling an order number 11.
My lord. Order number 11, my lord. Earlier, my lord.
Just 1 minute. You're all right. What was the interim order you were enjoying?
My lord, interim order, my lord, initially passed, my lord, on, my lord, 14.
What is the
24
nature of the interim order you were enjoying? Asking you a very simple question, sir. Status quo with regard to what? Possession, with regard to construction, with regard to nature, what?
My lord, nature and change of nature and character.
Nature and character. That's the only thing
Fine.
you were enjoying.
Fine.
Only one point. Can a court at the time of disposing of the injunction application made certain findings which would kill the suit itself? Can it be done? Tell us.
My lord, my respectful response to that query, my lord, would be that, my lord, the documents prima facie.
I am asking you a simple legal question, sir. It's a legal point I am asking you. Law. Can the court at the time of disposal of injunction application made such a finding which would kill the suit, render the suit not maintainable?
If such observation is it is uncalled for, my lord, that cannot be, in my respectful submission, cannot be made at that stage, my lord.
Then,
But my lord,
then how the court, he has gone, everything he has done, he has said that co-sharers are not weight party, everything, that the suit, there is nothing in the suit. Because that really strikes at the root of the jurisdiction and the maintainability of the.
I can understand your lordship's
Whatever is, whether the property is a joint property, whether the property is a separate property, that's the question to be decided. But pending that, how one can change the nature and character?
I can understand what your lordship, what is falling from your lordship and what your lordship is not able to countenance at this stage, my lord.
Yes.
But equally important, my lord, the fact remains, my lord, that I will just place one document to show your lordship that this application is malafide, my lord.
Malafide.
In certain sense, my lord. Yeah, I am a son of a mother who is 80 years old. I am living in my property, which
You remain there. Who is going to disturb your position?
I'm constructing a house, repairing a house rather for my mother.
No, repairing will not affect. Only thing is that changing the nature and character.
My lord, then
Mere repairing does not change the nature and character. You can do it. You can't construct a 4-storied building there
Has
instead of a mud house.
He has constructed a 3-storied building already. Let us have 2 rooms, then I don't want to construct anything. He already constructed 3-storied building, my lord. He has constructed on his part, my lord, a 3-storied building. Let us have 2 rooms for mother and son to live there. I don't want anything. I don't want any construction. Let it remain status quo, my lord. Let us have 2 rooms for my mother and me to live.
Where are you living? You are living on
My
a
own
ground.
share, on my own share.
So you remain there.
But my lord, once there is a status
You
quo,
remain there. Who is going to disturb your position?
my lord,
Nobody. Is a status quo with regard to nature and character. That's all. Neither position nor your right is being impinged.
if nature and character is not allowed to be changed, my lord,
Correct.
if I am not allowed to build my house to
Now you say repair, sir.
rebuild,
Please
rebuild,
do not deviate from your stand. You just said repair.
my lord.
My reaction was this injunction will not prevent you from repairing. You continue repairing. We will make an observation. But if you say you want to construct,
My lord, I understand what it just fell from your
then
lordship.
the problem.
Lordship, just say one document may I place before lordship? One document.
What for?
My lord, my lordship will get a clear picture, my lord, what the
He
intent.
was enjoying an interim order. We'll hear you. You file your opposition at the time. We'll hear you.
My lord, then my lord, kindly allow me to repair and allow me to stay with my mother in their house only.
Yeah.
Are you staying in their house?
No, I am staying in my own house.
So can a court create a tenancy, create a licensee,
Says
create a
that
lease?
says, my lord, the property is joint property. Supposing he is right, my lord, it's a joint property. Then I have a share. I have a right in that part of the property also, my lord. He has not taken permission from me before constructing a 3-story house there, my lord. He says that I cannot construct because it's a joint property. He was also right. I agree. Fine. Then I also have a right in that property, my lord.
Go and file an application. Are you not aware of the concept of a joint possession? If a possession is given to one of the co-sharer in a joint property, then he remained in possession not only in commensurate with his share, but on behalf of the other co-sharers, unless he claims an exclusion. That's the different. He has not.
No, he has not.
If you say that you want to have, then you'll have to take out an application there. If your position was never there,
my case is
then after the partition, whatever the ultimate partition would come out, if he is in possession of that portion, he has to give up.
my
He
lord,
has to give up that position and will go to you.
my simple case is, my lord, the partition has already happened.
This is what is, the court has said 2 things.
his document, my lord. I'm placing
Please, the court has said 2 things. The court has said after the promulgation of the West Bengal Land Reforms Act, the partition must be deemed to have taken effect in terms of section 12 thereof. It does not talk about these 3 situations of section 12. So he disbelieved it.
my lord.
How can you now at this stage say, so it's better there's a nature and character, nothing of that kind. And I do not find that there is any allegation in this regard. You come, file your affidavits, we'll consider you.
My lord, then kindly allow me to repair and stay in my portion, my lord. Kindly make that,
In your portion, you are there.
kindly make that observations.
The in a suit for partition, an injunction application was taken out by the plaintiff appellant, and an ad interim order of injunction in the form of status quo with regard to nature and character of the suit premises was passed by the trial court. On a date of passing the impugned order, an application for extension of the said interim order, ad interim order, was taken out, but the court proceeded to dispose of the application for injunction. At the very outset, we must record that the observations returned in the instant in the impugned order has a vital impact on the maintainability of the suit, which should not have been done while disposing of an interlocutory application. Even if we consider such observation to be tentative, having no impact no impact at the time of final adjudication of the disputes, yet it has a persuasive effect on the hindsight of the mind of the judge at the final stage of the proceedings. We find that the court at one stage has observed that there is no deed nor a decree of the court relating to the partition having effected in respect of the suit property. Yet the court proceeded to dismiss this injunction application solely on the ground that the other co-sharers have not been implemented as a party, nor the entire property, which according to the learned judge constitute a joint property, have been included in the hodgepodge. Neither of the parties have taken up such plea as the contesting respondent took a categorical stand that in effect the partition was effected at a relevant point of time, which would be evident from the documents produced before the court. On the other hand, the plaintiff, the appellant contends that the property was never partitioned and remained in joint possession of the respective co-sharers. Such being the stand, if the court was of the view that the property is not partitioned, we do not find any justification in not extending the interim order passed earlier to stop. Essentially, the issue remained in such a suit is whether the property is joint or was partitioned at a relevant point of time on the basis of the assertion of the contesting respondent. Such issue needs to be decided upon full-fledged trial. And the finding which is returned at this stage could have been possible at the time of passing the judge, or at the time of delivering a judgment. We'll stop. However, it is contended by the contesting respondent that the plaintiff appellant have constructed a house and enjoying the position therein, whereas is creating an impediment in renovating and or repairing the existing house where the contesting respondents live with their family. Stop. It is apprehended that taking advantage of the order of status quo with regard to nature and character of the suit property, the plaintiff appellant may create disturbances and or obstructions in effecting the repairs and renovation of the existing structure in possession of the contesting respondents. We are quite alive of the proposition that in the event any construction is made on the joint property, it may sometimes bring an irreversible situation. And a person who has constructed the house, constructed the building, may claim an equity at the time of passing the final decree. However, we do not find any impediment on the part of the co-sharer in effecting the repair and or renovation of the existing structure standing on the alleged joint property, as every co-sharer has a right in respect of every inch of the property and the possession thereof is not incommensurate with the shares held by him in the said joint property, but on behalf of the other co-sharers as well, unless an exclusion is claimed. We therefore restore the order of status quo with regard to nature and character of the suit property, but that shall not stand in the way of making any repair and or renovation of the existing structure. Stop. In the event any construction is contemplated by either of the parties to the suit, liberty is granted to them to approach the court to seek a leave in this regard, which shall be decided by the court, independent of the findings made in the impugned order. Trial court. Approach the trial court.